Speaker.
I call Richard Prosser.
Thank you, Mr Speaker. I'm pleased to rise on behalf of New Zealand First and on behalf of my colleague Fletcher Tabato to take a call on this first reading of the Taxation Annual Rates for 2015-16 Remedial Matters Bill. New Zealand First will be supporting this bill, at least to the Select Committee in the first instance. Mr Speaker, bills of this type are generally, or at least we hope they are generally, of a largely non-controversial nature. This is an omnibus bill which makes amendments to no fewer than 10 other acts, with the intention that the current tax settings are improved within, as the general policy statement says, a broad-based low-rate framework. This is commendable intention, Mr Speaker, and we wholeheartedly support it. The general policy statement speaks of fairness, of evenness, of minimising biases, and the crucial nature of these things in terms of encouraging voluntary compliance, which is of course the basis of any successful long-term ongoing taxation regime. We do have some questions and a few concerns, in part regarding the sheer number of technical amendments and drafting clarifications contained in the bill, or more to the point, the fact that so many appear to have been necessary in what is a large number of acts affected by this proposed legislation, Mr Speaker. The taxpaying public and the business community have an expectation, I would contend a right to expect, that tax policy should be very thoroughly thought through and that all the bugs should be ironed out before it becomes law, especially given that the penalties for non-compliance are frequently very severe. That so many fixes appear to have been identified and will be addressed is a good thing, in the sense that we will gain a better tax system out of it, but at the same time it is concerning for New Zealand First that there were so many to begin with. Mr Speaker, I want to focus on a relatively small number of the areas in which we do have concerns, and these are things which we look forward to having examined in greater depth at the Select Committee. Amongst these is the review of the Child Support Scheme reform to amend the Child Support Amendment Act 2013. Mr Speaker, there are a number of inconsistencies within this review which we believe are worthy of closer investigation. Section 38, which would have introduced mandatory automatic deductions of child support from employment income, will be repealed. When non-compliance is already high, we have to ask, why is this provision being repealed? Section 38 would also have allowed discretion to recognise other payments, such as the payment of school fees and the direct payment of costs associated with additional extracurricular activities, such as camps and sporting activities and so forth, where they, as a percentage of child support payments, where these payments directly benefit the child. This is also to be repealed, Mr Speaker, and New Zealand First believes this is not only counterintuitive, but also counterproductive in terms of delivering better outcomes for children living in circumstances where they are, to a large degree, estranged from at least one parent. A new definition of adjustable net income, which includes income adjustments to taxable income such as income in trusts and companies, has also been repealed, and again we ask why. Inland Revenue states that changes to the Child Support Scheme reforms enacted in 2013 but not yet in force are being made to firstly increase priority of reducing child support debt and also to reduce the administrative cost of implementing the reforms. The June 2014 Regulatory Impact Statement prepared by Inland Revenue notes that there's been limited consultation on the options within their statement, given the timing restraints on decision making and the sensitivity of the decisions being considered. Inland Revenue's Regulatory Impact Statement considers whether other options might be cheaper but also just as effective. The question to be asked, Mr Speaker, is whether these chosen components of reform will effectively contribute to a reduction in child support debt. That debt now exceeds $3 billion, and some three-quarters of that amount is in the form of penalties, which of course do not benefit children directly. New Zealand First acknowledges that the 1991 scheme was in many cases out of date and out of line with social expectations as they have evolved. This undermines some parents' incentives to meet their child support obligations. The main change of the 2013 reforms was to shift the focus of the child support formula, now to be focused on the level of support that is required from each parent for each qualifying child. Over a greater range of shared care, the income of all parents of the child, including legal step-parents, and the average cost of raising a child were all considered by the 2013 reforms. These changes were in the original new amendments that were meant to be implemented on April the 1st. But now, 10 days after this 153-page bill, including its commentary, were tabled in the House, and with the original amendment having gone through 3 readings and passed with changes, this new bill changes key aspects of the child support system. And they're not small tweaks, these are big flip-flops. We ask why, Mr Speaker. If this is, as has been suggested by more than one commentator, with regards to Section 38, to stop common law being broken in the form of legalised theft through the mandatory deduction of contributions from taxable income, does this mean that the law has been broken up until now? Has this issue simply been overlooked at all these preceding stages of the bill, or that bill which is going to be amended, or is it because it's been decided that it will be too difficult and expensive to ensure the right process is taken, so the Minister has simply chosen to throw it out instead? Finally, why, with such big reversals and changes in some aspects of how child support is paid, does it appear to have been hidden in this great behemoth of a bill? If there were good reasons, Mr Speaker, New Zealand First would have been happy enough to have been appraised of them earlier than this, and probably to have supported them. Almost lastly, Mr Speaker, there is the matter of the cash out of research and development tax losses. R&D is recognised as a key element in the business growth and innovation process. High upfront costs associated with R&D mean that the profit cycle for R&D projects can be more heavily skewed towards early losses. This, of course, can be a significant barrier for innovative start-up companies, and current tax settings can create a cash flow problem for small and medium-sized businesses. These SMEs cannot offset R&D costs against existing streams of income the way that larger firms are able to do. They don't have the same buffer. Current tax settings can also penalise businesses which engage in R&D that ultimately turns out to be unsuccessful. Current tax provisions state that losses from unsuccessful R&D can only be used going forward if there is a subsequent profitable business. The proposed changes focus on start-up companies engaging in intensive research and development. The changes intend to reduce these companies' exposure to market failures and tax distortions. Clauses 192 and 213 deal with proposed eligibility requirements and the amount of the cash out. New Zealand First will be interested in the Select Committee's recommendations around the other clauses that deal with the administration and the reinstatement of losses. Finally, there are the reporting requirements of employers in the agriculture, horticulture and viticulture industries. Clause 224 repeals Section 240 of the Tax Administration Act 1994, a section which created a great deal of red tape and trapped employers in the agriculture, horticulture and viticulture industries with a requirement to provide Inland Revenue with information about employees covered by an exemption certificate or a special tax rate certificate. This section imposed unreasonable costs on employers and indeed unreasonable inconvenience on Inland Revenue itself and was not effective at identifying non-compliant employees. And we have to question whether there was ever much to be gained in the grand scheme of things by attempting to identify what is essentially a very low-end problem anyway. In closing, Mr Speaker, I reiterate that New Zealand First will be supporting this bill at least to the Select Committee. We do have some concerns. We look forward to examining the bill in greater detail there. Thank you.
Mr Speaker, I call Andrew Bailey.